Don't talk to him. Court calls the case People versus Thomas Styron.
I'm Stein, the living man. I'm here by special appearance to address this matter.
I'm sorry.
So I'm Thomas Styron, the living man, not Thomas Gilbert Styron, the entity you know me as, or as I'm in the papers. I'm here to address the matter.
All right. Thank you. You wish to be represented by an attorney, sir?
No, I'm here to address the appropriate persona.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand. Now. Mr. Allen, if you don't want to cooperate and handle things, he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say no. I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me?
No,
not today. Mr. Allen, take him. We'll bring him back out when he wants to cooperate. Yeah, I need an interpreter for the last two and that one.
May I swear the interpreter?
Yes. Is it for the last two cases?
Yes.
Yeah, that one will swear in.
I am Tariq Maratari Kade, the executor of the Tariq Maratari Kade Living Trust and the registered owner of the Tariq Maratari Kade Ex Relatione Kindaman Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the third degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend.
The courtroom barely had time to settle before Thomas Styron attempted to seize control of the narrative, declaring himself the living man and distancing himself from the legal name on the charging documents. But the judge shut down the performance instantly when Styron refused to stand where directed and appeared to challenge basic courtroom procedure. The judge didn't entertain the theatrics. Not today, he warned, ordering him removed until he was ready to cooperate. In a matter of seconds, the tone was set. This was a court of law, not a stage for philosophical debates or semantic loopholes. The judge made it clear that participation required compliance, and defiance would only delay, not derail, the proceedings.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role.
How what?
How religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No,
so I do have.
sir, what you're about to state is incorrect.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there
You
a
are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't.
Once back before the bench, Styron escalated his argument, claiming that adhering to statutory law violated his religion and invoking international declarations on indigenous rights. The judge methodically dismantled the claims, explaining that the proceeding was governed by Michigan Supreme Court rules, not personal belief systems or global policy statements. When Styron insisted religion should override court procedure, the judge drew a firm constitutional boundary. Faith does not exempt a defendant from criminal law. The exchange became a defining moment, authority versus ideology, and the judge refused to allow abstract arguments to override jurisdiction. In that courtroom, only one legal framework applied, and it was not negotiable.
Understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this
Yes, sir.
because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion. Yes.
Pardon?
Under threat, duress, and coercion. Yes.
No. Not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Anything from the people?
With the court, ask the people to prepare the order for the competency.
Yes, please prepare the order for that. Is that your address, sir?
Excuse me? That's correct.
All right, very good,
And so I will send a copy to that address.
very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry, can I get that date again, please, sir? If I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I
the
did,
court.
I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it, I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you
additional week.
stated at the last hearing.
Well, you
You
asked,
knew that, no, you knew it was supposed to be filed before the day. Young man, you're gonna
That's it.
figure out something. We're playing by my rules, not yours. So you do not say anything because you're gonna.
As Styron repeatedly claimed he did not understand the court authority, the judge pivoted from argument to protection of due process. If a defendant cannot comprehend the proceedings, the law requires intervention. What began as defiance now triggered a serious consequence, a court-ordered forensic competency evaluation. When Styron attempted to condition his cooperation on the prosecution, and court also submitting to evaluations, the judge immediately shut it down. You don't get to make the rules. The order was entered. A competency hearing was scheduled. The message was unmistakable. The court would not allow confusion, genuine or strategic, to obstruct justice. Before any trial could proceed, the court would ensure the defendant was mentally fit to stand before it.
Figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay, no problem.
What a courtroom showdown. Thomas Styron, a man who insists on being called the living man, has just put the court through a whirlwind, from rejecting legal authority to challenging the very foundation of the legal system. This case has everything: defiance, confusion, and a bold refusal to comply with state law. But let's break down the key takeaways. First of all, Styron's declaration that he doesn't follow statutory law because of his religious beliefs is a classic example of the sovereign citizen mindset. You've heard of it. People who argue they're not bound by the rules of the land they live in. But here's the hard truth. The court doesn't care about your personal beliefs when it comes to the law. This courtroom runs on state law, not your ideology. And this is where things really hit a roadblock. The judge was patient, offering Styron every chance to understand the situation. The court explained the charges, the penalties, and even offered him legal counsel. Still, he insisted he couldn't comply with court rules because it went against his religion. The judge had no choice but to reject that argument and move forward with a competency evaluation. You can't just decide which rules you'll follow based on your personal beliefs. It's about fairness, and it's about the law being applied equally to everyone. Then came the real turning point, when Styron questioned whether he'd voluntarily cooperate with the forensic evaluation. He said, and I quote, "Under threat, duress, and coercion, he would comply." That's where the judge drew the line. You can't hold the court hostage with conditions like that. This isn't about, bargaining for the best terms. It's about ensuring you're mentally fit to stand trial and fully understand the charges you're facing. The judge was clear. If you're competent to stand trial, you'll follow the rules, no exceptions. And let's not forget the big picture here. Competency. The court doesn't just do this to be difficult. A competency evaluation ensures that anyone standing trial fully understands the charges against them and can adequately defend themselves. Styron's behavior raised enough concerns that the court had to ensure he wasn't just playing games. A competency hearing has now been scheduled for July 25th, 2024, and once Styron's competency is confirmed, he'll be expected to follow court procedures like everyone else. This includes filing motions on time, respecting the authority of the court, and most importantly, abiding by the law. This case is a stark reminder that regardless of personal beliefs or ideologies, everyone is bound by the same legal rules. We all have to follow the law, no matter how we feel about it. The courtroom is where justice is served, and no one, not even someone claiming to be a living man, is exempt from that. So what do you think? Was the judge too strict with Styron, or was this a necessary step to maintain order in the courtroom? Let us know your thoughts in the comments. And if you've been as riveted by this courtroom drama as we have, don't forget to hit that like button, share your thoughts below, and subscribe for more gripping legal breakdowns. We'll keep bringing you the latest in courtroom action so you don't miss a thing.
Even as the hearing concluded, Styron attempted one final procedural maneuver, questioning filing deadlines and challenging the court's handling of his motion. The judge's patience narrowed into a sharp warning. We're playing by my rules, not yours. With competency now pending, all other motions were frozen. Bond was continued, and the next appearance was locked in. The spectacle ended not with triumph, but with a clear judicial reset. The courtroom had absorbed the disruption, reinforced its authority, and moved forward under established law. Now, everything hinges on July 25th, because if competency is confirmed, the arguments end and accountability begins.